Last week I joked with you with tongue firmly planted in cheek that it seemed like we've been together for a long time and we are growing old together. Well, here we are another week later and we're still here. But this is the last time that you'll hear from us. As the judge has said, we have rested our case, and this is an opportunity for us to summarize the evidence that we presented to you not only in the penalty phase, which we didn't take a lot of time to do, but also in the guilt phase of this particular case, on why in this particular case your verdict should be that the defendant, Luis Toledo, should be sentenced to the death penalty. Now, in cases such as this, in this phase of the case, a lot of attention is focused on the defendant, and that's important. And all of the evidence that was presented to you by the defense, I submit to you, you should consider. We'll have some arguments about that ourselves, about how much you should consider that. But that's important, so I don't want to downplay that. But that's the way this phase goes. A lot of the attention is focused on the defendant, his background, and things of that nature. And what sometimes gets lost in that, and even it got lost, I think as Mr. Will stated in our opening statement, was it sort of got lost in the guilt phase as well, because a lot of attention was focused on Yesenia Suarez and her relationship with the defendant. And what got lost in that were the other victims in this particular case, Talia and Michael Otto. Now, in this particular phase of the case, it is the convictions for their murders that are the focus of your attention in this particular case. You have found the defendant guilty of the second-degree murder of Yesenia Suarez, and that conviction is where that stays. When we move into this phase, the only convictions that you will be considering for the imposition of the death penalty are the murders of Talia and Michael Elijah Otto, who were 8 and 9 years old when the defendant murdered them. Now, on August the 23rd of 2013, one of the things we don't really know is the extent to which Talia and Michael were aware of the turmoil that was surrounding them in their household. We don't necessarily know that. There's some indications. We heard from Felicia Perez, who said she went and picked the kids up from school that day when she heard about the incident at American K-9. She took them to her home, and then the defendant and Yesenia came to her house, and they had a conversation in the garage away from the children. But what we do know is that they had nothing to do, absolutely nothing to do with the turmoil between the defendant and Yesenia Suarez, and that is important. They are completely innocent victims in this case, and it's important that we keep that in mind. They were guilty of nothing, absolutely nothing, except being present at the time that the defendant, Luis Toledo, made the decision to kill his wife. Now, the judge, in a few minutes, is going to read you some jury instructions, and these are instructions that will apply in this particular phase of the case. And part of those instructions will tell you sort of what your role is in this case. And what he's going to tell you is now your duty. Whenever we're finished making the arguments and when he's finished instructing you on the law, it will be your duty to make a decision as to the appropriate sentence that should be imposed on the defendant for the crime of first-degree murder. And that's 2 counts. 2 counts of first-degree murder with both of these children. And there are 2 possible punishments that you would render to the judge, and that is life imprisonment without the possibility of parole and death. And the judge will also tell you that those instructions that you read you, those are the law, that you must follow the law. It is set out in those instructions. And then if you fail to do so, your decision will be a miscarriage of justice. And so while there is no requirement that you return a verdict for the death penalty, it is important that you follow the instructions that the judge reads to you, and I know that you will. So how do you go about making this decision? Well, your decision is essentially going to be based on 4 questions. Number 1, has the state proven at least one aggravating factor beyond a reasonable doubt? At least one. And as we told you in our opening statement, there are several that we were going to present to you, and we have done so. So the first question is, has the state at least proven one of those aggravating factors beyond a reasonable doubt? Number two, are the aggravating factors that you find, are they sufficient to warrant imposition of the death penalty in this case? And number three, do those aggravating factors outweigh the mitigating circumstances found to exist? And lastly, based on those considerations, should the death penalty be imposed in this particular case? Now, when we're talking about aggravating factors, the judge is going to tell you, and sometimes the word may seem obvious to some and maybe not so much to others, but what the judge will tell you that an aggravating factor is a standard. It's a guide to the jury in making the choice between recommending life imprisonment or without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of the crime or the harm to the victim. The death penalty is not sought in every first-degree murder case. The death penalty is reserved for those cases that are the most aggravated and the least mitigated in the facts in those cases. And so these aggravating circumstances help guide you. Why is this case different? Why is this first-degree murder case different than any other first-degree murder case? What makes it one of the more aggravated circumstances and one of the least mitigated cases? And we're going to talk to you a little bit about that today. The first aggravating factor that we have presented to you, and the judge will give you instructions on this, is that the defendant was previously convicted of a felony involving the use or threat of violence to another person. That's the first aggravating factor we presented to you. Number two, that the murder was committed for the purpose of avoiding or preventing a lawful arrest. And this applies to both victims in this particular case. Number two, that the murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Again, this applies to both Michael and Leah Otto. The third aggravating factor the state has presented to you is that the victim of the murder was a person less than 12 years of age. Again, this applies to both Michael and Leah Otto. And then lastly, that the victim of the murder was particularly vulnerable because the defendant stood in a position of familial or custodial authority over the victims. And the two victims here, Michael and Leah Otto. So what evidence has been presented to you? Now the state has to prove these beyond a reasonable doubt. So what evidence have you heard in this particular case as to each of these aggravating factors and that prove that these factors exist beyond a reasonable doubt? So let's talk about the first one. The first aggravating factor that the state has presented to you is that the defendant was previously convicted of a felony involving the use or threat of violence to another person. And you heard testimony in this particular case from a young man by the name of Eric Preolini. And he told you about how he was living down in South Florida one night, several years ago, when a man knocked on his door. And he goes to the door, he had a friend of his over, and this man, he opened the door, and it was a man he didn't recognize, who was asking about this person who he did not know. And when he told him that he didn't know it, he went to shut the door, and he noticed the man on one side, and then a man to the other side, and then suddenly these three men barge into his house, and there's a fight. And during this fight, a gun is pulled on him. And he's put on the floor, and his gun is held to his head. And he's tied up. And the girl is tied up. And these people go through the house, ransacking his house, looking for things to steal. And they take items from him. Some jewelry, some rings, his beeper, a chain, $100 bill. And then they leave. And he told you about how he felt. That he felt in fear of his life. And when these men left, he called the police, and they were pulled over shortly thereafter, not far away. And he goes to the scene, and they're caught. He calls his beeper, and his beeper's in the car. And one of the three men that came into his house with guns, put him on the floor, held him up, robbed him, invaded his home, and stole from him was this defendant, Luis Toledo. Now, not only did he tell you the story about what the defendant did, not only is that evidence in this particular circumstance, But the defendant was convicted of that crime. He was convicted under a different name, Michael Garcia. And you heard evidence from a fingerprint technician who examined the fingerprints from the judgment since the conviction, the paperwork that's filed with the court, to the defendant's fingerprints, and they matched. They were one and the same person. You also decided in this particular case that the defendant was guilty of the crime of second-degree murder of Yesenia Suarez. That also can be considered as a prior conviction of a felony involving the use or threat of violence to another person. And also, the conviction, we were talking about one of the convictions of either Michael or Talia Otto. You can also consider that as well. Now, you can only consider that as one aggravating circumstance. All of these merge into one. However, when you consider each of these, the robbery of Eric Creolini, the home invasion, as well as the murder of Yesenia Suarez and the murder of the children, you can consider those and increase the weight that you give this particular aggravating circumstance. So I submit to you that this aggravating circumstance has been proven to you beyond a reasonable doubt and that you should give it great weight. And you've already found those last two. You've already found those beyond a reasonable doubt by virtue of your conviction of the defendant for second-degree murder and first-degree murder of the children. You've already found those last two circumstances exist beyond a reasonable doubt. So what does this tell us? Why does this make this type of crime different from other murders? Well, it shows that this was not an isolated incident of a single bad decision by the defendant. It establishes the defendant's complete and utter disregard for the rights of others. It also demonstrates that these murders were not impulsive acts. And it illustrates the defendant's willingness to harm others for his own benefit. It shows that he is willing to inflict violence on his targets. And it shows the defendant's true character in this particular case. And I submit to you, you should give this aggravating circumstance great weight. So the second aggravating factor that the state has presented to you is that the murder in this case was committed for the purpose of avoiding or preventing a lawful arrest. Now, what does that mean? Well, it means that in this particular case, the reason that the defendant killed Michael and Talia Otto was to eliminate them as witnesses. And you have to look at this in the context of time. Okay? When you stop and consider, when did he kill Michael and Talia Otto? Well, he killed them after he killed his wife. He caught her in this affair. He confronted her. There was an argument at home, and he killed her. Now, after he killed her, the children were there. And you heard from his own statement, the children came out, and they were asking questions. Where's Mommy? What's wrong with Mommy? Who's dead? And that's when the defendant killed Michael and Talia Otto. And it's important to understand because at that moment in time, again, like I said before, these children had done nothing to the defendant. The only reason for him to kill them was to make sure that they would never tell what they knew. And it was the defendant who did it. He was there. He was all alone in that house when his wife was killed. Is the only explanation. There's no other explanation in this particular case other than the defendant killed Michael and Talia Otto solely to eliminate them as witnesses in this particular case. And so I submit to you, this aggravating factor has been proven to you beyond a reasonable doubt and that you should give it great weight. The third aggravating factor the state has presented to you is that the murders in this particular case were committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And the judge is going to explain to you, he's going to read you some instructions about what this means. He's going to tell you that cold means the murder was the product of calm and cool reflection. That calculated means having a careful plan or a prearranged design to commit murder. And that in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a period of reflection, a substantial period of reflection is required. Now, as you know, first-degree murder requires premeditation, and this requires a higher level of premeditation. So what do we know from the facts of this particular case? From the defendant's own statement, as I just told you, the children came out after he killed his wife. And we know from the blood evidence that Talia Otto's blood was found in the master bedroom and in the master bathroom. And so when Talia Otto, as the defendant said, came out of the room and saw what had happened, they make their way to the bathroom. And here at the edge of the master bathroom door, her blood is found on that middle hinge where she struck. Leroy Parker, the blood spatter expert, said all of these blood stains in the bathroom, in his opinion, were the result of, they were impact or cast-off stains. And so she struck here at the door of the master bathroom. And there are blood stains, blood spatter at the bottom of that door, showing that after she was struck, she fell and she was hit again. And the evidence shows that she moved. She moved into the master bathroom in the area of the tub where she struck again with the axe. And the evidence shows that she moved further into the bathroom, into the vicinity of the bathroom cabinet where she struck again. And as Leroy Parker told you, that these blood stains, as they make their way into the bathroom, get lower and lower and lower until those last blood stains are found at or near the floor, where I submit to you is where Talia Otto died. Now, Michael Otto, we don't know exactly how he died, other than what the defendant said. The defendant said he also was taken into the bathroom and where he was struck with that same axe until his head felt like puzzle pieces. So how does this evidence prove that this murder, these murders of these children were cold, calculated, and premeditated? Again, it has to be viewed in the context of Yesenia Suarez's murder. The children were only murdered after the defendant was killed. And the murder was not fueled by the defendant's anger towards the children. It was motivated by his selfish desire to avoid responsibility for these crimes. Killing for this purpose requires special calculation. This is not someone who is angry or in a rage. This is someone who has decided to end someone's life to save their own hide. And that requires a very special calculation in this particular case. The opportunity, when you stop and think about it, to substantially reflect on his actions is clearly demonstrated by the fact that he killed not one child, but two children. He killed one of them and then went and got the other child and killed them as well. He had plenty of time to think about the first one after he killed his wife, but he certainly had plenty of time to think about what he was doing before he killed the second child. And there can be nothing more cold-hearted than the murder of an innocent child. And so I submit to you that this aggravating factor has been proven to you beyond a reasonable doubt, and that you should give it great weight. The fourth aggravating factor that we have presented to you is that the victims in this particular case were less than 12 years of age. And we've heard clear evidence of that. I don't want to speak for the defense, but I don't know that there's a lot of dispute about this. We know that Talia Otto was 9 years old, and we know that Michael Elijah Otto was 8 years old at the time of his murder. Why is this important? Why is this factor make this crime more aggravated than other first-degree murders? And that was because at this young age, at their young age, they were utterly and completely defenseless against somebody of the defendant's age, against his size and his strength. And you heard him talk about in his interview about doing mixed martial arts and karate, and he knows his own strength. These children were no match whatsoever. They were just little children. They weren't adults. They weren't somebody the defendant's own age. They weren't somebody the defendant's own size. They were no match whatsoever for the defendant. And that's why this crime is different than most first-degree murder cases. And I submit to you, this aggravating factor has been proven to you beyond a reasonable doubt, and you should give it great weight. Lastly, that the victims of the murder were particularly vulnerable because the defendant stood in a position of familial or custodial authority over the victims. And you've heard it. They were not his biological children. And I submit to you, that's why it made it easy for him to dispose of them. But at the same time, he was still married to their mother. They considered him their stepfather. And as a result of that, he was in a position of familial or custodial authority over them. Young children, they depend on an adult for every need that they have. And that dependence gives them no choice whatsoever but to trust an adult to protect and provide for them. And that's what they did. They trusted the defendant. They trusted him to protect them. And of course we know they were only 8, 9 years old at the time. They had no choice but to trust him. And without their mother, they were completely defenseless. Now the judge is going to tell you that this aggravating factor, what they call merges with the one before, the one that shows that the children were less than 12 years of age. I submit to you, while his instructions to you, that those can only be counted as one aggravating factor, even if you find both of them. I submit to you that if you find both of them, that should increase the weight that you give that aggravating factor. So, let's talk about mitigating circumstances. We've heard a lot of evidence in this particular case about mitigating circumstances. And the judge is going to read you some other instructions about that as well. And what he's going to tell you is that a mitigating circumstance can be anything in the life of the defendant which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating factor can include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this particular case. He's also going to give you some other instructions, and I'm not going to read this, but basically what he's going to tell you is that when it comes to mitigating circumstances, it is the defendant's burden to prove those. Now, they don't have to be proven at the same level that the state has to prove the aggravating circumstances, but it is their job to prove that the mitigating circumstances exist. And they have to prove that by a standard of greater weight of the evidence, which basically means the evidence is more likely than not. It tends to establish the existence of that mitigating circumstance. So that's important to know. And it's up to you to give that evidence such weight as you determine it should receive. You're the ones that decide, number one, whether the mitigating circumstance exists, and if it exists, how much weight you would give it. Now, the judge will also tell you that the process of weighing the aggravating and the mitigating circumstances is not a mathematical calculation. You don't count up how many aggravating circumstances there are, and you don't count up all the mitigating circumstances that you find that there are, and then simply whoever's got more, that's what wins out. It's not a mathematical calculation. It is a weighing. You have the ability, you have the right, your responsibility to assign each of those aggravating and mitigating circumstances weight, and then decide whether the ones that exist on one side outweigh the ones that exist on the other side. So, for example, you can find, and I submit to you, and I argue to you, that the aggravating factors that we have proven to you should be given great weight. And one analogy that I would offer to you is you may find that an aggravating factor does in fact have great weight. And if you, in your mind's eye, would picture an iron cannonball, you may find that it has the weight similar to an iron cannonball. And there may be 3 or 4 of those aggravating circumstances. And then you may find a number of mitigating circumstances in this particular case, but yet find that they weigh, the weight that you should give it is no more than a BB. And there may be more BBs than cannonballs. But at the end of the day, it is the weight of the cannonballs outweigh the weight of the BBs, then that weight outweighs the other. And so I encourage you, as you go through the weighing process, to keep that in mind. What he's going to tell you is that after the weighing process, your verdict in this case must be either one of 3 things. You have 3 options in this particular case. Number 1 is a unanimous sentence of death. In order for you to return a verdict for the death penalty, your decision must be unanimous. That means all 12 of you that will be deciding this case have to decide to return that verdict of death. Number 2, it could be a unanimous sentence of life without the possibility of parole. And then lastly, a non-unanimous sentence of life without the possibility of parole. If it's not unanimous for death, then it's a life sentence. So let's talk about some of the mitigating circumstances that you've heard from in this particular case, and I expect you to hear argument today regarding. One of the mitigating circumstances that will be argued to you today is that the defendant did not have the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law was substantially impaired. And you've heard a lot of testimony in this particular case from doctors. You heard from Dr. Eric Means. You heard from Dr. Joseph Liu. You've heard from Dr. Heather Holmes. And from their testimony, you can gather that there were a number of things that they claimed, a number of psychological disorders that the defendant had that substantially impaired his ability to appreciate the criminality of his conduct or to conform his conduct to requirements of the law. You heard evidence. You heard Dr. Eric Means testify that it was his opinion that the defendant suffered from a minor neurocognitive disorder. You heard him testify that it was his opinion that the defendant had bipolar disorder. You heard testimony that the defendant had a seizure disorder. And you heard evidence that testimony that he had traumatic brain injury. So let's talk about the evidence that you heard with regard to the minor neurocognitive disorder. Dr. Mings told you that he performed a battery of neuropsychological tests on the defendant. And it was as a result of these neuropsychological tests that he gave to the defendant that he reached this particular conclusion. And he told you that he gave him an IQ test, the Wechsler Adult Intelligence Scale and the Wechsler Memory Scale. One was an IQ test and one was a memory test. He said these are neuropsychological tests that he gave, and these indicate a neuropsychological disorder with the defendant. However, and he said the defendant, when he took the IQ test, he tested an average range. But he said the indication of the neurocognitive problem was that his verbal reasoning score was substantially below his nonverbal reasoning score. And he said that the differences reflect a combination of development factors and traumatic brain injury. And I'm going to talk a little bit more about the traumatic brain injury in a little while. But this is the testimony that he gave, that all these times that he was hit in the head or whatever, that he suffered a traumatic brain injury, and this was the result of why he's got the neurocognitive disorder. Well, you also heard from Dr. Meadows. Dr. Meadows went and he sat with the defendant for 2 hours. And then he also reviewed Dr. Ming's report. And he told you that the testing that Dr. Ming's done was not a complete neuropsychological workup. Because an IQ test and the memory scale are good tools to conduct a neuropsychological exam, but you don't stop there. That if there's some indication on a IQ test and memory scale that there might be some problem, you do further testing. And he said Dr. Means did not do that. And it makes you question why. Why did Dr. Ming stop there? Well, he also told you that Dr. Ming misinterpreted the difference between the verbal and the nonverbal reasoning scores. And what he told you was that only if and he said it was the opposite of what Dr. Ming had told you. He says only if the nonverbal reasoning scores was substantially lower than the verbal reasoning, would that be an indication that there is some possible neuropsychological issue. He said it was the exact opposite. Because if it was the way Dr. Ming said, that would be no indication of a neuropsychological problem. He told you that the most likely explanation for the lower verbal reasoning score was education. And we heard a lot of testimony about that from the records, that the defendant dropped out of school in the 9th grade, and that prior to that he had been kicked out of school a lot. We heard some testimony that he was in special education classes, but we also heard that a lot of times children with behavioral problems are in those same kind of classes. And the defendant had told a previous doctor that he was in those classes because he was, quote, too bad. So this makes perfect sense. The defendant's level of education was not great. And that, Dr. Meadows said, was the most likely explanation for his lower verbal reasoning scores. He also told you that the nonverbal reasoning scores was actually quite high. It was actually quite high. What he also told you is that when you're making a diagnosis of any mild neurocognitive disorder, moderate what he told you was that you're going to expect that person to be at like the 16th percentile. In other words, you're only scoring higher on these tests than about 16% of the population. That's like 84% that are doing better than you. However, he said that on this portion of the exam that Dr. Means gave, the defendant was testing in the 73rd percentile. That means he's doing better than 73% of the population. He's almost in the top 25% of the people who take this exam. Dr. Meadows also talked to you about adaptive functioning, because you do not diagnose somebody with a neurocognitive disorder without going through an adaptive functioning analysis. And he told you that he asked the defendant questions about his life, and he said that his adaptive functioning was quite fine. He could drive a car, he could handle his finances, he was in barber school. All the things that you would find with someone with a neurocognitive problem did not exist in his evaluation of the defendant. You also heard testimony that the defendant suffered from a bipolar disorder. We heard testimony from Dr. Means, and we heard testimony from Dr. Heather Holmes. With regard to this, the only evidence that anybody has provided in this particular case, other than their own opinions, were notations in the prison records. And those, Dr. Meadows told you, were inconsistent. Sometimes the prison system diagnosed them with bipolar disorder. Other times they diagnosed them with a major depressive disorder. And he said that's inconsistent. We also know from Dr. Meadows' testimony, or from the records, from the other testimony that was presented in this particular case, the defendant was never diagnosed with bipolar disorder before he went to prison. He was not diagnosed with bipolar disorder when he left prison. He was, and most importantly, this was something that Dr. Meadows emphasized in his testimony. Prior to the defendant ever going to prison, he was in a psychiatric facility with doing competency training for several months. All right, and this facility has trained mental health professionals watching the defendant every day. That's what they do. They're there to provide mental competency training. And not a single time during the time that he was in this facility did they diagnose him with bipolar disorder. Then, when he left prison, from the time he left prison, which was in 2007, till the time that he was arrested on this particular case, which was in 2013, that was 6 years, there was no evidence of any symptoms of bipolar disorder, even though he was not on any medication. And you heard testimony in this particular case that bipolar disorder is one of those, is a disorder where you have these fluctuations between this mania to this severe depression. And these manifestations of this illness are quite obvious to people. And if you're not taking medication, those symptoms will reoccur. And they would be expected to reoccur several times during a period of about 6 years. But there is no evidence whatsoever in this case of the defendant suffering any symptoms of bipolar disorder between the time he left prison and the time that he was arrested in this particular case. It seems like the only time that he's given this diagnosis is when he's incarcerated. And that's important because even Dr. Means admitted that when it comes to criminal cases, there is a high motivation to malinger mental symptoms when a person is facing charges or when they're incarcerated. And we know that this is not unusual to the defendant because he has a repeated history of malingering. And he was malingering in this case. Because Dr. Meadows told you that he attempted to administer the Minnesota Multi-Phase Personality Inventory, which is a personality test. And that test includes a test for bipolar. If the defendant reports symptoms it's going to show up on this test. But the problem is that after he administered that test, the results were invalid. And the reason that the results were invalid is because the defendant was endorsing too many symptoms. And Dr. Meadows told you that the defendant was not approaching the test with honesty. And so the efforts to malinger continue in this particular case. Traumatic brain injury. There were claims in this case that the defendant suffered traumatic brain injury. What evidence did you hear as to that? Well, we heard that when the defendant was 6 years old, he ran into a wall. At 6 years old. But there's no records of that. We found out that when he was 10 years old, he fell off a bike and injured his knee. And Dr. Means said he didn't find anything important about that in terms of this. And so I don't want you to think I'm misleading you, but the fact that there are records in this particular case is important. Well, then we find out that when he was 11 years old, a year later, he was hit in the eye with a ball by a friend his age. And there are records of that. And then a year later, he fell off the bike again when he was 12 years old. There's records as to that. And then in 1997, when the defendant is approximately 15 years old, we heard testimony that the defendant reported that he had been involved in a car accident and that he had injured his back and he had had a concussion and he was in the hospital for 4 days, 4 weeks. I mean, the testimony was several different time frames. But there are no records of this either. And then we heard testimony that in 2000, when the defendant was 18 years of age, he had suffered a gunshot wound to the face and the scalp. And there are records as to that. What's important is that in all the records we do have, there's absolutely no indication in any of them that the defendant suffered any type of brain injury. None whatsoever. Now, with regard to the car accident, there are no records, and the reason why it's important that there's no evidence of that, because there are no records, is because when you look at all the times that he went to the hospital, and there are records, this falls right in the middle. So as far back as 1992, when he was 10 years old and he fell off the bike and injured his knee, we have records from that time frame. But when we're talking about this car accident, and this came out during cross-examination, was that the PET scans are not a standalone test. And look at a PET scan by itself and say that there is a traumatic brain injury here, that there is low impulse control simply by looking at the PET scan. He has to have other evidence of that, evidence that corroborates what he might be seeing on the PET scan. And that's important. And the reason it's important because his conclusion about the frontal lobe abnormality, that's the part of the brain that's on the very front, it's the part that controls impulse and things of that nature. He said that it was totally based on two things. Number one was the evidence of the traumatic brain injury. and the result of Dr. Ming's battery of neuropsychological tests. And as we have already pointed out, there was no evidence whatsoever of any kind of traumatic brain injury. The defendant, on all those occasions that he went to the hospital, saw doctors. And none of these doctors ever did a CT scan. They never did an MRI. They never did a PET scan to determine if what Dr. Wu is saying occurred actually was the case way back when those things happened. And now Dr. Wu, all these years later, is now saying there's traumatic brain injury because he ran into a wall or because somebody hit him in the eye with a ball. Even though those doctors at the time said, made no notations about any such injury. And then Dr. Ming's battery of neuropsychological tests. We've already talked about how he didn't really do a full workup of neuropsychological testing. And then we heard from Dr. Holder. Dr. Holder is a doctor of nuclear medicine, which includes PET scans. He's been doing it for over 40 years. Not only has he been doing it for over 40 years, he's board certified in nuclear medicine. And not only is he board certified in nuclear medicine, but he was on a panel to determine other doctors, whether or not their education and their experience rose to the level of being a board certified doctor in nuclear medicine. So he knows his stuff. And he told you that his review of the defense PET scan was completely normal. Completely normal. And he told you about how a lot of times doctors will look at PET scans and he will tell you that everybody's brain is a little different. And there's going to be some variation between one person and the next person. But those differences oftentimes are within the range of normal. And that's what he said in this particular case, that the defendant's brain scan was within, the PET scan was within the range of normal. The other thing he told you, which I think is very important, is that the use of the PET scans, the use that Dr. Wu is putting to these PET scans, because they're very good for cancer detection. They're very good for cardiology. They're very good for detecting Alzheimer's disease and monitoring the progress of Alzheimer's disease. And the reason he said that it was very good for that is because over the years they've done all of this research, all of these empirical studies, and those studies have developed to the point where they can use the PET scans in a reliable way to detect these things and to monitor its progress. He said none of that is the case with regard to determining whether or not a person has low impulse control from a traumatic brain injury. He said it's great research. People are doing it now, but organizations like Medicare do not fund these types of things because it's not reliable. It's not reliable. So all of the things that Dr. Wu was saying is not generally accepted by the scientific community, and it cannot be relied on. And you heard Dr. Wu talk about this case from a long time ago, Phineas Gage, man who was tapping the explosive rod, and the rod exploded and went up through his brain, and he was a completely different person after that. Well, that's not the case here. That's an extreme example. That's a completely extreme example. The defendant did not tap an explosive rod and have it go through his frontal lobe. The claim here is that he ran into a wall when he was 6 years old and that a friend hit him in the eye with a ball. That's what we're talking about here. And so when we're talking about this level of evidence, it's just not reliable, and you should not consider it. And if you consider, say, for example, if you say, you know what, the standard isn't very high. You know, maybe I'll just, it tilts just a little bit in the defendant's favor, which is fine. You're the one that makes that decision. I submit to you that Dr. Holder's testimony that this is not reliable science should cause you to conclude that it should not be given much weight at all. We also heard evidence when it comes to the capacity of the defendant to appreciate the criminality of his conduct and conform his conduct to requirements of the law, that they was substantially impaired. We've heard evidence of seizure disorder. And I'll tell you, the state does not dispute that the defendant may have suffered from a seizure disorder at one point in time. That's one of the things that's in the records that there seems to be fairly decent evidence of. The question, though, is when did it stop? Now, the defendant told Dr. Meadows the last time that he had suffered a seizure was when he was in prison, and that was at least 10 years ago. At least 10 years ago. And there's not had any seizures since then. Now, Dr. Wu tried to come in and say that he has non-convulsive seizures, which is convenient because, again, the records show he hasn't had seizures in a long time. And so now we're doing this backdoor extrapolation that the defendant has to have non-convulsive seizures. However, there's been no prior diagnosis. You've heard no evidence whatsoever, any prior diagnosis of non-convulsive seizures. There's no evidence, no records that says that. So again, let's talk more about the capacity of the defendant to appreciate the criminality of his conduct or conform his conduct to the requirements of the law. Here's what's key to all of this. What point in time are we talking about? Okay? Is this a disorder that he has that just generally lingers throughout his life? At what point is it that he is actually impaired by one of these disorders that you may find that he has? It's at the time of the murders of Michael and Talia Otto. And why is that important? Because there has to be a connection between the disorder and the defendant's thinking and conduct at the time he committed the crime. And what evidence do we have of that? The question is, did a disorder, if you find that the defendant had one, did it impair his capacity to either, one, appreciate the criminality of his conduct or conform his requirements, his conduct to the requirements of the law at the time that he murdered these children? So what evidence do we have of that? Well, even if there was some indication that the defendant suffered from one of these disorders, there is no evidence that it impaired his ability to appreciate the fact that he was murdering these children, that was a crime, or to stop himself from killing them at the time it was committed. And the reason we don't know, there's no evidence of this, is because Dr. Means and Dr. They never asked him. They never asked him, were you in one of these manic states? Were you in one of these severely depressed states? He didn't ask him that. What were you feeling at the time? And that's important. How can you conclude that someone with some type of mental condition was substantially influenced if you don't know what was going on inside their mind at the time that the crimes were committed? Well, we heard from Dr. Holmes about the defendant, the diagnosis of bipolar disorder, and she specifically told, and this was in answer to the defense attorney's own question. She said she can't relate bipolar disorder to this crime. There's a lot of people that have bipolar disorder that have never committed a crime. And then we have the defendant's actions. What is he doing after he murders the children? He disposes of their bodies. He cleans up the crime scene. He gets rid of the trunk mat. He gets rid of the cleaning supplies. He gets rid of his boots. He gets rid of his clothes. He's getting rid of everything that had any connection to this crime. He's throwing away the evidence, which shows that he knew at the time that what he was doing was a crime. He was trying to cover it up. Again, you have to look at the defendant's murder in context with the murder of their mother. While her murder may have been fueled by anger or rage, their murder was committed for the simple fact that he was trying to cover up what he did. And that shows that he appreciated the criminality of his conduct. And the evidence also shows that he had the ability, there's no evidence otherwise, to conform his conduct to the requirements of the law. Now, the judge is going to read you a jury instructions about experts and how to view their testimony. And he will tell you that experts are like every other witness, with one exception, that the law allows them to state their opinion, because on a matter that you believe them to be an expert in. However, like any other witness, you have the ability to believe or disbelieve all or any part of an expert's testimony. Now, when you're talking about the fact that they are to be treated just like you would treat every other witness, the judge will reach some additional instructions about judging a witness's reliability. He will tell you that when considering aggravating and mitigating circumstances, it is up to you to decide, not me, not the defense attorneys, it's up to you to decide which evidence is reliable in this particular case. And you should use your common sense in deciding which is the best evidence and which evidence should not be relied upon you in making your decision as to what sentence should be imposed. You may find some of the evidence reliable, and some of it is reliable, I submit. But you may find that other evidence is not reliable or less reliable than other evidence in this particular case. So let's talk a little bit about something else that we heard, and that was a diagnosis of the defendant having antisocial personality disorder. And let me be very clear when I talk to you about this. This is not an aggravating circumstance, okay? However, this explains, I believe, what's really going on with the defendant. Because a lot of people would look at these crimes and say, who in the world would kill 2 young children? Who would do that? What sane person? The only kind of person that would do something like there's got to be something wrong with them. And so there would be a tendency, perhaps, to believe that there is some mental disorder that caused them to do something so egregious. Well, you heard from Dr. Meadows, and Dr. Ming said he doesn't necessarily disagree with this, but what's really going on with the defendant is that he has antisocial personality disorder. And what that is a pervasive pattern of disregard for the rights of other people. That's what's really going on with the defendant. And that is not a mitigating factor. He was diagnosed repeatedly of that during his prison term. And Dr. Meadows said when he met with him and evaluated him, he would give him that same diagnosis. Again, Dr. Ming said he didn't necessarily disagree with it. This is not a true mental illness. This is a character defect. This is a character defect, not a mental illness. That is what's really going on with the defendant. You heard testimony about school records. We only have them up for the 9th grade. That's it. There's nothing else. And those school records, to the extent that they exist, they said showed the defendant was making Fs at the time. Testimony was that he was in special ed classes. But we also know, as I said before, students with behavioral problems are in those classes too. We know from the evidence that he was expelled from several different schools. The key thing here is that the IQ test that Dr. Mings gave him showed that he was of average intelligence. So he had the ability. He had the ability. It was just the application of that ability. So this was not a situation where somebody simply was not smart enough, and that this, because of that, that should be a mitigating circumstance. Or it would be a mitigating circumstance that should be given a lot of weight. We're talking about a person here of average intelligence. He had the ability to at least do reasonably well, maybe not a straight A student, but at least do reasonably well in school. And so when you consider that as a mitigating circumstance, I submit you should not give it great weight. You're going to hear a lot of other mitigating circumstances, and I'm not going to spend the time to go through these individually. There's going to be a lot of others. You're going to see a list, and that list is going to be longer than the list of aggravating circumstances. The reason the list is going to be longer, or at least the list that we have in terms of aggravating factors, is because our aggravating factors is limited by law. And so, again, as you go through this, when you see these aggravating circumstances, these mitigating circumstances are going to be claimed, again, do not simply do a mathematical calculation. Say, well, there's more of them than there are the aggravating circumstances. And so, therefore, because of that, it simply should be a life sentence. So, and I'll submit to you that some of these, I believe the evidence is established by the standard the judge is going to give you. Maybe not all of them, but some of them are. I don't want to be misleading here. He spent 7 months in a psychiatric ward when he was 9 years old. We heard some evidence of that. We have no reason to necessarily dispute that. We don't know why he was in the psychiatric ward. He was diagnosed with behavioral issues. I believe that's been established. That's part of our argument, that we're not talking about someone with a mental disorder, we're talking about somebody with behavioral issues. He attempted to better his life by obtaining a GED and attend technical school. Well, ladies and gentlemen, I submit to you, when you consider that as a mitigating circumstance and you're determining what weight to give it, we're talking about a person who had the ability, an ability to lead a law-abiding life, but chose not to do it. Long history of head injuries and concussions. We've already talked about that. And others. So, again, I'm not going to go through all of these. But I want you to carefully consider each of these. And to the extent that you find them, then that's fine. But I submit to you, at the end of the day, when you consider the aggravating circumstances that exist in this particular case, the fact that the defendant, on multiple occasions, has committed violent felonies against people and has been convicted of those crimes. When you consider the fact that in this particular case, he murdered these children to eliminate them as witnesses. When you consider the fact that these murders were cold and calculated and premeditated, when you consider all those aggravating circumstances, and then you weigh them against the mitigating circumstances, there can be no question that they outweigh the mitigating circumstances. At the end of the day, this case is about real people. Michael and Toledo. And it's sometimes when we simply see a picture of someone, kind of like when we go to Walmart and we're going down the picture frame aisle and we see pictures in a picture frame. It's just a face. It's just a face on a piece of paper. But at the end of the day, this is about real people. An innocent little girl, an innocent little boy, who may have had no idea of what was going on around them. They did nothing. Absolutely nothing to this defendant. Nothing. Their only crime was being present when he killed the one person. The person who gave birth to them. These children trusted. They trusted their mother to protect them. When children have nightmares in the middle of the night, where do they go? They go to their parents' bedroom, place of safety and security. On this particular night, when they went into their mother's and the defendant's bedroom, they were running into a death trap. The end of the road for them. That's what this case is about. Little did they know that the man that they trusted, that their mother married and trusted to provide for them, protect them, would be the one person that would take their life. For all the reasons that I've argued, all of those reasons is why the only appropriate sentence in this particular case is the death penalty. In a few minutes, the judge is going to read you those instructions. And you're going to go back into that jury room. And you're going to discuss all the evidence. It's going to take not majority of you, 7, 8, 9, 10, or 11 of you. You take 12 of you to decide this case. It's only going to take one of you to say no. To say no. The death penalty should not be imposed. But I am asking you here today, based on the evidence that you've heard in this case, that the state has proven all these aggravating circumstances beyond a reasonable doubt, that they are sufficient to warrant the imposition of the death penalty, that those aggravating factors substantially outweigh the mitigating factors in this particular case, And that because of that, the only verdict in this particular case should be the death penalty. I'm not asking 7, 8, 9, 10, 11 of you to render that verdict. I'm asking all 12 of you. All 12 of you to render that verdict.